We're ready for our final talk then. 4:30. We may not get through everything in the final slide, but no problem. The next thing can needs be. But where does that take us? Working through conflicts of interest, you're being aware to the fact that a conflict can arise in innumerable different circumstances, and they may be difficult to identify from time to time, but generally speaking, you'd expect them to fall into one of those three broad categories: corporate opportunities, competing directorships, and transactions involving self-interest. It's the latter where you've got a nice, you've got a very clear legislative framework that you're working through. So a great area to introduce issues in problem question as far as directors' duties are concerned. Just following through then, duty to act for the proper purposes of the company. In Carlisle, we've forgotten by now, but the court said that a director must act for the proper purposes of the company. And that includes exercising powers in accordance with the company's constitution. So we talked about that this morning, in the context of the saving provisions and the impact on the third party. But remember, again, those carve out the fact that the director remains liable for exceeding their powers, whether those powers which are delegated to them or those powers which exist within the company's constitution as a whole. Again, no different from the position under the English law. A director must exercise his powers in accordance with the terms upon which they are granted, i.e., he must comply with the company's constitution and do so for a proper purpose. And there were various cases that dealt with that, and again, you could read up on them in the study guide, but generally, often concerning, as in Piercy and S. Mills, the issue of shares or the dealing with share capital in a way which is designed to perhaps protect an existing majority or to create a new majority. And that was the case in both Piercy and Howard Smith. Certain of the directors are basically abusing the power of the company to issue new shares or to allot new shares, and in doing so, create new majorities, maintain existing majorities when in fact they probably shouldn't. And in both cases, the court held that the offending directors were in breach of duty, but improperly exercising that power to issue new shares. But again, I'm conscious of the time, so you could read up on those in a bit more detail, but that's the bottom line. There are clear examples of directors being held to be in breach of their duty to exercise their powers for a proper purpose. They've exercised the power to issue new shares simply to create new majorities or to maintain majorities in certain circumstances. And creating new majorities includes destroying an old majority, I suppose. As a red flag, though, that would be too obvious an issue for me in terms of putting together a problem question. It's too obvious. Conflicts of interest is much nicer because it's something you can hide away a bit more. Remedies then, what are the remedies available for breach of duty? Well, there's no exhaustive list. It's going to depend entirely on the circumstances, but as you'd imagine, kind of headline remedy is going to be damages to compensate a company for whatever losses it suffered as a consequence of the relevant breach of duty. In circumstances where there's been a misappropriation of property, then it could include the restoration of the property to the company. In cases concerning, for example, the making of an improper profit or taking of improper remuneration or the taking of a corporate opportunity, an account of profits made by the director. The court can grant an injunctive or declaratory relief in order the rescission of a contract. But the discretion of the court is as wide as ever. But generally, in my experience, it won't be keen to get involved, as I said earlier, with trying to unpick transactions and undo contracts. If there's a simple solution that the company is compensated financially for the losses it suffered, that is the order that the court will make, because it's clear and straightforward. And I've only ever, the only alternative I've ever dealt with is where an order was sought that property be returned to the company, notwithstanding that these equivalent remedies exist under the English law. I've only ever seen damages or restoration of property. Nevertheless, if you're advising on a scenario involving some directors and a breach of duty, irrespective, I guess, of who you're advising, whether it's the company as to what remedies they may seek, or the director as to what liabilities may he be subject to, you need to give some consideration to what is the practical outcome here in terms of remedy. So that may require a little lateral thought on your part as to what would be appropriate in any given circumstances. The issues relating to directors' duties, the exercise of powers by directors, the conduct of directors generally is subject to two final points. One, ratification by the company, and on the next slide, the granting of relief by the court in limited circumstances. It's possible then under section 160, subsection 1, for the company to ratify conduct of the director which amounts to negligence, default, breach of duty, breach of trust, or in circumstances whereby he's otherwise exceeded his powers. Again, you can read through the detail in sections, subsections 2 through 5, but by way of a spoiler, subsection 2 says that the power can be exercised by the members. Ratification can be exercised by the members voting on an ordinary resolution, unless the memo or art say anything require a higher majority. So ratification by the members could, under subsection 2, be affected by as low as an ordinary resolution, thereby reflecting the principle of majority rule. Would you generally see a higher threshold?
No, I mean, so, and I've only really seen ratification, and it's there to protect the directors. So, you know, you could get to a situation where, you know, fundamentally mistakes have been made. Mm-hmm. So, you know, to protect the directors, this is what you would suggest, but because it's an ordinary resolution and the interested parties can't vote on it, mm-hmm. It's really only a remedy where you've got a closely held company, mm-hmm. And you're just trying to, you know, to make the director feel more comfortable because it's something which he has done, because the shareholder wanted him to. So we use it curative in that sense. It wouldn't work for a fund or a widely held vehicle.
Yeah. Yeah. So again, I'm conscious of the time, but you can read through those provisions because they are pretty straightforward.
The protocols just section 3
section 160, subsection 4 disregards the votes of the relevant person.
Okay.
No, don't apologise. Don't apologise. I didn't explain it. So. But you're right. My caveat was you can read it for yourself. But no, his votes are disregarded. But also not just the affected member, but anyone with a direct or indirect personal interest, so as to cover spouses, etc. And it's only limited to their involvement on that particular resolution. And everything else at that meeting, they can vote in neutral. And again, something which I'm not sure I've ever seen in practice, but an equivalent provision exists under the English law, the granting of relief by the court. So the court has the discretion to relieve a director from liability for negligence, default, breach of duty, or breach of trust, either wholly or in part, as the court thinks fit, if it's satisfied that the relevant person acted honestly and reasonably and ought fairly be excused. You've got an example of this in SPL Guernsey, where the court was influenced, I've noted, by the approach of the Court of England and Wales. So there's no significant body of case law dealing with this in England and Wales, though there is some. Re-welfare, I'll come on to in a moment, which I think is the main example. In any event, in SPL, the Guernsey court held that it's the obligation, the burden is on the director to prove that he acted honestly and reasonably. But it's an objective test the court will apply to the reasonableness. And those, in that case, in SPL, the court refused to grant relief. At least it takes that principle slightly further. The burden is on the director to prove honesty and reasonableness, and it's an objective test for reasonableness. And what would the reasonable director have done? In re-welfare, you have a case where a company is trading at a loss, so it's verging on insolvency, and the decision is made to sell the business of the company. And two offers are received. There's the higher offer, which is made clearly on the basis that in the event it was accepted, the business would effectively be stripped for parts, it would be sold off, profit we presume, and that would be the end of it. It would be sold for parts by the purchaser. The lower bid, which was received, was on the basis that the company, on the basis that the business would continue. Employees would remain in their positions and it would simply continue under new ownership. And ultimately, the decision was made by the board to sell the business for the lower sum, so as to protect the position of employees, so as to ensure the continuation of the business. The company itself then, as a shell, enters liquidation, and the liquidator brings misfeasance proceedings against the directors on the basis that the liquidator alleged had acted in breach of duty to act in the best interest of the company, breach of the duty to promote the success of the company, all of that by selling to the lowest bidder. The court, though, and the test in England and Wales is exactly the same. The court was satisfied that the two directors should be granted relief on the basis that they acted honestly and reasonably. And in all the circumstances, their decision had been motivated by the protection of the employees' interests and the continuation of the business as a going concern. I always thought that that would be something which would happen quite often, but it's not. I've never seen it. I don't think I've ever seen a practical example. Typically, cases don't tend to get as far as court, I suppose. But I've never seen one of those applications.
It seems strange because I don't know if the purchase money would have gone to the shareholders.
The purchase monies would have gone to the creditors of the company because it was.
Oh, they were going to buy it out of insolvency.
It was verging on insolvency, is what I have in the back of my mind.
Yeah, but if they were going to keep it as a going concern, then that little money would give them a low offer to shareholders. And the same goes for the high offer.
No, because the proceeds of sale would have gone into the company in insolvency. It did enter liquidation. Whether it was compulsory or not, I don't know. But point being, the proceeds of sale go into the pot. Don't
Oh,
they?
I didn't realise that. I thought the person. So
No, so they
I
couldn't.
actually misunderstood the beginning of it.
So they couldn't have made a distribution. They had, obviously, as they did, outstanding significant creditors.
You want to, I mean, under the New Companies Act, you were able, there's not that kind of cascading things to factor in, employees figure something.
It would have been probably would be a preference. I think it would be clawed back if you sold your business at a time when you're in those circumstances. I think it would be clawed back. And on the facts, but I would be amazed if you could get away with just taking the proceeds of sale and walking off.
Just remember, when you're in the zone of insolvency, then you have to start thinking about your creditors, not your shareholders. So,
I'm thinking of the members of the company. The shareholders can do what they want. They can start. They don't get clawed back. The clawback works against directors, isn't it?
Not insolvency. You're not allowed to do anything that could potentially prefer one of the creditors over another. So
No, but if you're the shareholder of a company, the company's going fast. It's not your company. That's not like spend. Unless I've missed something to be fundamental for such a long time. That's how you can sell your company for £1, you can sell it for £100, you can sell it for 10 million. That's a massive going concern.
as long as you're not actually in, you haven't passed your resolution to wind up, because once you've passed that, then you can't physically transfer the shares, you're not allowed to. But before that, in principle, you could sell your shares, or the directors could determine to.
there's actually a number which would probably be
It's so facts.
Yeah,
That's the difficulty. My general point was I would be amazed if you could get away with it. I take what you're saying. Yeah, you can sell a company for £1, absolutely. But here we weren't selling for £1; we were selling for proper value. And at the time, you had issues with distributions. It's 1990. It would be slightly different now, but I'm not sure of the transaction minimum value, but I think you would fall into the clawback provisions. I think the directors would have a problem, certainly. And as such, that would influence how they treated the receipt of the proceeds of sale.
I'm just thinking of the show. It's just the show stuff. You don't want to.
I just think it's more complex than that.
Yeah.
Don't do anything without legal advice if you're in insolvency or heading that way, I think is the moral of the story. It seems quite unusual facts, but they did this.
But in any event, ignoring all of that, it still comes back to the fact of, well, in any event, should the directors be relieved from liability for selling to the lowest bidder? Because on the face of it, they were in breach of their duties. But what underpinned their decision-making process, the court was satisfied with, and so relieved them from any potential liability.
Once they come to a decision, like you were saying before, Frank, about taking into account, it's not about getting the right deal from the client side.
Yeah.
The highest bid is not always the best deal necessarily. You see that as anyway, I think we're going off on a bit of a tangent, but I can see why there would have been excuse here.
Yeah, absolutely. No, I agree. I agree that with the outcome. My kind of concluding point was, I'm surprised it doesn't happen more often.
Yeah.
There's not a greater body of case law dealing with this. But as I said,
Yeah.
in fact, I'm just thinking back to we've been dealing with this, the fallout of this leisure group, and I think probably only in passing have I even commented on the fact that you could potentially apply to the court to be relieved from liability for breach of duty. Maybe I should reflect on that advice, but it's just not something that I really thought about, as being something we ought to explore. Notwithstanding, because, and yes, this is the third time my directors are probably as guilty as sin. But I don't always act for the bad guys. I know this is a common theme. But, it's just what happens. Okay. All right. Well, look, an hour. Can we do this? Possibly. It depends how well you remember the rule in Foss and Harbottle. So here we cast our minds back to law school days, and I remember thinking, well, what on earth is all of this about? But we know well enough now, don't we, in practice, quite simply, if a wrong's been suffered by a company and the proper claimant in respect to that wrong is the company itself. The company is a separate legal person. And so if the company suffers some loss, it has the power to pursue a remedy in respect to that loss. It can commence proceedings in its own name. It can be sued in its own name. So that probably doesn't need any further elaboration. The principle, though, is so hugely important because it's led on to development of a kind of spider's web of remedies in certain circumstances. And it's what then leads into the distinction between personal actions, representative actions, derivative claims. It's kind of what led the groundwork for the development of the unfair prejudice petition. All based on the fact that, yes, the company is the proper person to bring a claim in respect of a wrong which it has suffered, but invariably the wrongdoers are in control of the company. And the wrongdoers, of course, aren't going to want to direct the company, to compel the company to bring a claim against themselves as wrongdoers. So hence why the rule in Foss and Harbottle, don't think about it, but it underpins all of these subsequent developments in the law, because it was necessary to develop exceptions to that rule so as to enable often the aggrieved minority to bring proceedings either to protect their own position or to advance a claim on behalf of the company when the wrongdoers are preventing that claim from being brought or simply not doing anything about it. So Foss and Harbottle then, fundamental principle, it lays the groundwork for derivative claims and for prejudice, etc. I've noted Prudential briefly. Prudential is all about the concept of reflective loss, and it works through the justification of the rule in Foss and Harbottle in practice as a consequence of the fact that during the 20th century, the English courts struggled with the idea that when the company suffers loss, say an asset is misappropriated, it as a company suffers a consequential reduction in its value. An asset is taken, so the net value of the company falls. As a consequence of that, the value of shareholdings is reduced. They're simply a proportionate amount of ownership in that company. When the value of the company drops, the value of the shareholding drops. And the court struggled with, well, what do the shareholders do then? Property has been misappropriated. The value of the company has been reduced. The shareholding investment value has been reduced. So should the shareholders not be able to pursue a claim in order to claim the difference in share value that they've lost? The problem with that, though, of course, is that if the company pursues a claim, it retrieves the property, its asset value goes back up, and the share value goes back up. In Prudential, the court termed that reflective loss. If the shareholders were permitted to pursue their own independent claims for their loss of share value, and the company pursued its claim for loss of property, if that claim is successful, then the shareholders would obtain a double recovery because they still own the shares. The company is successful in its claim, the share value goes back up, well, the shareholders are happy. And at the same time, they've pursued their own claims and they've enjoyed the boon of a double recovery. So that's what Prudential is all about, this idea of reflective loss. Yes, it's recognised, it's acknowledged. The shareholders suffer loss when the company suffers loss, but that doesn't give them the right to pursue their losses independent of the company. It's for the company to seek a remedy for the loss that it's suffered, because once it's successful, once it achieves that remedy, its value increases, and in turn, that increases the shareholder value, their investment value. And in theory, everybody should be happy. So that is it doesn't depart in any way from the rule in Foss and Harbottle. It just took until 1982 to get a clear statement from the court of what reflective loss is and why shareholders shouldn't be permitted to pursue independent claims for loss of value when a company suffers some loss of value itself. Aside from that, you have then personal actions, you have representative actions, and then we can look to exceptions to the rule in Foss and Harbottle, which come up on the next slide. But a personal action, again, I hate to sound condescending, but anything which is actionable by a shareholder by way of a personal right. So a shareholder has limited personal rights which attach to them personally under that contract of membership. So, for example, the articles, contract of membership, will bestow the shareholder, potentially, with a right to a vote. It may not be, of course, you have different classes of share, but let's assume that's the case. That is a right which is personal to them. And the court recognised in McDougall that if the shareholder is then prevented from exercising that voting right, that is something which they can pursue personally. They can bring a claim for breach of contract, breach of the articles, because that right to exercise that voting right, that is personal to them. Again, the more common application of this I've seen in practice, this is going back some years, I don't deal with this kind of thing at the moment, but the exercise of preemption rights, where a member enjoys preemption rights to acquire new shares when they're issued before anybody else. And actually that doesn't happen. And the shares are offered elsewhere before they're, if at all, offered to the shareholder. That preemption right is personal to the shareholder. And so they exercise that right personally. They can bring a claim for breach of the preemption right. There's no exhaustive list. It depends obviously entirely on the constitution of the company in question, but certain rights we can identify as being personal to a member, to a shareholder, and they can seek remedies in respect of those rights. A representative action, the court recognised in Pender and Lushington, is where you take a group of shareholders or a class of shareholders whose personal rights have been infringed in the same way, and you simply lead a single action by when you have one lead litigant. But again, the representative action is simply a grouping of personal actions, if you like, where a class or a group of shareholders have been affected and their own personal rights infringed. Those don't give any particular, don't present any particular issues, but just to separate them out, to make it clear that those are quite distinct from the various exceptions to the proper claimant rule that the court went on to set out in Edwards and Halliwell, and which ultimately led to the development of the derivative claim. So, personal actions concern a claim arising from a personal right. A representative action is simply an action which brings together a grouping of claims arising from a breach of personal rights, perhaps across a class. The exceptions in the rule in Edwards and Halliwell, of which I'm not going to go through all of them because, frankly, the four that they set out, 3 of them are not really true exceptions. The exceptions in Edward and Halliwell are treated to be true exceptions to the proper claimant rule. So here, exceptional circumstances where a shareholder, a member can bring a claim as an exception to the proper claimant rule. And I've highlighted, not highlighted, I've set out the true exception to all of this, because as I said, there's 4, but it's only this one which is really the true exception. So a shareholder will be permitted to sue on behalf of the company where a fraud has been perpetrated against the company by the majority. And the majority could therefore seek to block any attempt, to prevent any attempt to seek relief by the company itself. So company has suffered some wrong and the wrongdoers are in control. It remains that the rule in Foss and Harbottle applies because the proper claimant is still the company. The company has suffered wrong. It is still the proper claimant, but in Edwards and Halliwell, an exception to that rule in these limited circumstances, where the wrongdoers are the majority, where they are in control, a shareholder or a grouping of shareholders will be permitted to bring a claim on behalf of the company. And the wording used, a fraud perpetrated against the company. And it's that phrasing, fraud, which then led on to other issues, as I'll mention in a moment, in the development of the case law. But that's the basic position, and that's carried through now into what we recognise as the derivative claim. A claim brought by a shareholder on behalf of the company, but key to this, the relief sought is still for the company. It is not for the benefit of the individual pursuing the claim. The relief sought is for the company. And it's for that reason that there's been basically no take-up of derivative claims in the UK, despite the fact that we have a quite nice, user-friendly statutory formulation of the derivative claim brought into great fanfare with the 2006 Act, but which nobody ever uses. Because you sit down with your client to discuss it, and you say, well, this is great, you can bring a derivative claim, make a preliminary application, we'll get permission, then we'll run the claim. You've got to fund it, but the remedy goes into the company, to which they say, right, so what do I get out of this? Well, the satisfaction that you pursued this claim, and that ultimately, going back to Prudential, you recover your reflective loss, because the value goes back into the company. Okay, they say, but the wrongdoers are still in control. Pursuing the derivative claim does nothing to change the status quo in the company. Brilliant. The wrongdoers are still in control. You've just obtained an award for damages of £100,000. If they even pay, that money is just going back into the company, and the wrongdoers are still in control. The status quo doesn't change. So as much as I said, it was introduced with great fanfare, and this was supposed to be revolutionary, I've talked about derivative claims on many an occasion, but nobody ever wants to pursue them. But that is nevertheless the exception, Edwards and Halliwell, which is the true exception of the four that they set out, and it's the one which then underpins what we now recognise as the derivative claim, a claim brought by a shareholder in respect of some wrongdoing suffered by the company, some wrong suffered by the company in circumstances where the wrongdoers are in control and would otherwise seek to avoid a claim being brought. It is, though, a claim for the benefit of the company, and so the remedy is for the company. There's then a couple of cases that deal with how we interpret all of this. The idea in Edwards and Halliwell wasn't anything particularly new, in that in Burland and Earl, the court recognised some 50 years prior that there may be circumstances in which the majority could seek to take benefits or advantages for themselves, which weren't otherwise, which other members of the company would otherwise be entitled to participate in. It was from Burland and Earl that the court in Edwards and Halliwell took its fraud, its use of the term fraud. There in Burland and Earl, you see, they refer to when the majority are endeavouring directly or indirectly to appropriate to themselves money, property, or advantages which belong to the company, or in which other shareholders are entitled to participate. That was the intention of the use of the term fraud, but nevertheless, that seemed to get lost in translation. And in Edwards and Halliwell, although that was the link, that was why they were using the phrase fraud, the court didn't actually really go on to expand what that meant. And so there were some cases then that followed where there was uncertainty as to, well, what does fraud actually mean? Is it akin to the criminal offence of fraud? And so you then follow through to Daniels and S. Manco, where the court moderates the point in Daniels and Daniels, confirming that fraud extends to self-serving negligence. So directors who use their powers intentionally or unintentionally, fraudulently or negligently, in a manner which benefits themselves. So it's not just general fraud, general negligence that would satisfy the term fraud in Edwards and Halliwell. It's the use of powers fraudulently or negligently, but only in circumstances where the directors themselves benefit at the expense of the company. In that definition then, Daniels and Daniels moved and advanced the principle on somewhat, because prior to that, the focus had very much been, as in Edwards and Halliwell, on the majority being at shareholder level. But in Daniels and Daniels, the court extended that and recognised the majority may simply be at director level. And in fact, much more likely. The directors, irrespective of whether or not they're shareholders, it's the directors who, exercising their powers of day-to-day control, may have sought to benefit themselves at the expense of the company. And in S. Manco, the court kind of sought to put the final nail in the coffin of discussion as to what fraud meant, and said that fraud seems to be used as comprising not only fraud of common law, but fraud in the wider equitable sense of the term. So why they didn't just say, look, in Edwards and Halliwell, you shouldn't have said fraud. It's much wider than that. Obviously, the court didn't want to be too critical of what was a leading decision. But irrespective of the use of that term in Edwards and Halliwell, it is much wider than that. And we are simply looking, as in Burland and Earl, for some kind of conduct, and in Daniels and Daniels, that leads to certain stakeholders, directors or shareholders, taking or using their position as majority to take some advantage which others would be entitled to otherwise share. There was no statutory formulation then of the derivative claim in England and Wales until it was introduced with the 2006 Act. But going back to the 80s, there was this call to create a better framework for claims to be brought based on that exception, Edwards and Halliwell. And there is now a statutory derivative claim. It comes with an initial gateway. You have to apply to the court for permission. If the court grants permission, you can then pursue the derivative claim. The reason why there's a checking mechanism is because the company is bound into the action, so could suffer costs, etc. That will be exposed to costs. But as I said, it's simply not used, or unless there's some, I don't know, particular practice outside the provinces where it's used, I really don't know, but it's certainly not something which anybody ever has any appetite for. Nevertheless, in Guernsey, the court recognised in Jackson, as I touched upon earlier, the use of the derivative claim, and commented, the rule in Foss and Harbottle applies in Guernsey as it did in England before the change in the law brought into English law by section 260, section 3 of the 2006 Act. Now, that's important because subsection 3 is what massively relaxed the circumstances in which you could bring a derivative claim. If you go back a step, I'd said that what the court focused on in Daniels was giving clarity to what was meant by fraud in Edwards and Halliwell. And as much as they referred in Daniels to cases of self-serving negligence, what was important were the various factors that made up the court's definition. Intentionally or unintentionally using powers at director level, fraudulently or negligently, in a manner to benefit themselves at the expense of the company. So it was still very much tied to this idea that the directors themselves were gaining some kind of benefit. Section 260, subsection 3 of the Act, however, relaxes that. And in fact, under subsection 3, you could bring a derivative claim in any case of negligence. It doesn't matter necessarily that the directors haven't gained some personal advantage, recognizing the fact that they may have acted negligently, they may have caused the company to suffer loss, and because there's a viable claim against them, they're still using their position of control to stop the claim being brought, notwithstanding that they didn't personally gain anything from it. And so it's covering off any other act of negligence or breach of duty. The 2006 Act doesn't allow that to be a stopping mechanism, if you see, for derivative claim to be brought, whereas historically under the common law it was. You had to prove that some personal advantage had been derived from a breach of duty or negligence. So 260 subsection 3 relaxes that, but hence the position of the court in Jackson, that doesn't follow through in the Guernsey law. It seems that they're still taking the stricter view that was taken pre-2006 in the English courts, whereby you are still looking for some personal benefit to have been gained by the directors. That at least is my reading of the view that the court came to in Jackson, because that's the only relevance that I can see of subsection 3 of the Act and the changes that it made to the English law as between pre and prior 2006. It's taken away, it's removed that element of looking for personal gain by the accused directors. Guernsey hasn't gone that far. It seems to still be sticking with the law as it stood prior to that, i.e. you've got to prove not only your breach of duty or negligence, whatever, but that there's been some personal benefit gained by the relevant directors. Have there been any discussion? Is this something you talked about around the water cooler?
I'm trying to call another matter. One where I think they mentioned double derivative.
That was in Jackson.
Was it Jackson? Was it actually Jackson? Okay.
So in Jackson, they mentioned double derivative claims and said, yeah, happy with that.
Okay, so that's actually
Yeah, it was subconsciously you'd already read on. It was going to be my next point.
Okay, so there's always the one case.
It's all right, Lauren. You just steal everybody's fun. You just lead the class. So no, in Jackson, the court also confirmed it was quite happy with the principle of the double derivative claim. Going back to what I said earlier, circumstances where you've got shareholders in a parent company, in a topco, and the issues, the misconduct, etc., are in a subsidiary. The derivative claim can still be brought by the ultimate beneficial owners to follow through that corporate chain. And in fact, you don't just stop with double derivative claims, and they refer to multiple derivative claims following through a more complicated corporate structure, either in a hierarchy or laterally. You can follow those links through, which is very good. The Guernsey court should be commended for that, because the English courts don't. It's never been excluded, but frankly, if you talk to some of the judges in the district registry, so the local high courts, about a double derivative claim, they'll probably just stare at you until you felt uncomfortable and walked out, because it's just not something that comes through that often, I suppose. We just don't have that clear statement.
Just to follow up on one question, we haven't kind of comment. I keep ringing up and saying he wants to reinstate a company. And then,
Oh, right, okay, yeah.
but we're kind of struggling.
I've advised on that before, yeah. I said, yeah, if you want to, we can do that. But why?
Yeah, yeah.
that was the answer to the question. Yeah, fine, carry on, but why? Why are we doing this? Because again, I'm going to win. Happy to take the money. but what are you going to get out of it at the end of the day? Because you've just restored the status quo as it was prior to the company being dissolved or whatever.
And again, the shareholder is kind of have this notion of this state as well. So, close to this.
Depends entirely on the facts. Maybe he's the sole beneficial owner. Maybe he will get something out of it. But my goodness, it's a long route to getting around it. But brilliant for fees. That's why we're here, isn't it? I always say my job would be much better if I didn't have clients, but they are a necessity. On the facts, though, Jackson, the derivative claim failed. The court wasn't satisfied. The plaintiff had made out a face. Made out a prima facie case that satisfied the underlying substantive claim. Really hard. Not even funny. Yeah. So that's fine. So great, brilliant. We've got derivative claim on Guernsey, and you can follow through a multiple derivative claim if you so wish. But your advice may be different. My advice to my clients, which is, well, look, you can do it, but why? Because certainly in England and Wales, what the court wants to see is a petition for unfair prejudice. Now, the provisions here in Guernsey, they're no different to those which exist in the English law. The Jersey law makes provision for unfair prejudice, but my understanding is that there's no real uptake of it over there. In fact, quite unusually, I think, they use the J&E winding up as a much more flexible kind of process for achieving various different aims in different circumstances. There's quite an interesting discussion from my point of view, because in England and Wales, and I think possibly here in Guernsey, subject to maybe what you say, we don't use J&E windings up. The court does not like it. It does not want to see the apocalypse for a company. It wants it to continue as a going concern. And that's what the unfair prejudice petition can facilitate. Whereas in Jersey, they're very much using the J&E winding up as this kind of more flexible vehicle for, initially it was affecting what I would know as a pre-pack administration. Put a company into insolvency, you buy out the business, and you put into a new vehicle. And that's effectively what they're using the J&E winding up for, but for more flexible purposes as well. That's all entirely on tangent. Section 349 sets out your petition for unfair prejudice in the Guernsey law. It's no different to how it looks in English law. A member of a company, and bear in mind there's no limitation there on minority or what have you shareholdings. It's simply a member of the company may apply to the court for an order under section 350 on the ground that you've got two slightly different scenarios. And how it kind of is then applied by the court. The affairs of the company are being or have been conducted in a manner that is unfairly prejudicial to the interests of the members generally, or some part of the members, but to include at least the petitioning member himself. So that's dealing with historic events under subsection A. It has been or are currently being conducted in a manner which is unfairly prejudicial, or looking to the future, an actual proposed act or omission would be so unfairly prejudicial. So it depends how picky your High Court judge is back home, but you should probably make sure that you cast the petition on the right grounds. Either you're looking to current or prior conduct, or you're looking to current or proposed conduct, acts or omissions. So A, current and prior, and we're just looking general, at a general course of conduct. B, we're looking current and future, but we're looking to specific acts or omissions. So a slight nuance, and in reality it probably doesn't make a huge amount of difference, but I know counsel tends to be picky on how they plead it. Just on that point, you can take a bit of assistance from the case law as to how you interpret what that actually means. Ring Tower, the court recognised that this is a test of unfair prejudice. It's not a test of unlawfulness. And so conduct can clearly be lawful, notwithstanding that it's unfairly prejudicial. So the test is not of unlawfulness. Possibly slightly more useful, Sam Weller. Unfairly prejudicial has two separate constituent parts. It means that the conduct must be unfair and the conduct must be prejudicial. You must satisfy both limbs, because you could, in theory, have conduct which is unfair, but which is not prejudicial, or conduct which is prejudicial, but which is not unfair. It's necessary to tick off both points. And you would assume they tend to come together, but not necessarily the case. To look more Guernsey-centric, though, you see in the matter of Midland Resources Holding, there's a few cases dealing with unfair prejudice petitions that you could look to in the study guide, I think, where the courts say prejudice is to be interpreted broadly. It includes, but is not limited to, financial prejudice. Not sure how much further that takes you, but at least it's a Guernsey case that you can cite. And you know that prejudice is to be interpreted broadly. So there can't be an exhaustive list of what prejudice is. So could the court have done any more? Possibly not. What was interesting, though, in Midland Resources, the petitioner, the applicant, seeks an order, as in the usual way, unfair prejudice, typically, that the applicant shares be bought out. And this is what I find slightly surprising. The court didn't make an order for sale of the applicant's shares on the basis that the terms proposed lacked sufficient detail. They would not achieve a clean break between the parties. Now, sometimes you need to go beyond the judgment, don't you, to actually understand what the issue in the pleading was. But that surprises me, because the approach of the court in England and Wales is quite simply, you petition for the relief that you want, i.e. you want your shares to be bought out. And that's it. You don't need to come to court with a proposal, because the court in its discretion can deal with all the procedural transactional issues that follow from that. Here, clearly, the Guernsey court was expecting a clear, defined proposal for how to move forward in the event that there was to be a sale of the applicant shares. Again, it would be useful to kind of see it from inception, how it was pleaded and put together through to the judgment, because you can only glean so much information from it. Did any of you have any? It did result in a genuine. It just intrigued me that the court didn't feel it could add to the overall.
Also went to appeal this matter. I'm not sure on which.
It ended with a JNE winding up,
Yes,
which I was going to come on to, but that's where this was just they sought relief on two grounds. So a petition for unfair prejudice, and they proved the unfairly prejudicial conduct. This is what I really struggled with. They proved the unfairly prejudicial conduct, but the court was not satisfied with the proposal for relief. And on that basis, it didn't grant relief on the petition. It did grant a JNE winding up. The one comment of the judge I like is coming back to the proposal from her prejudice. There are so many uncertainties, I cannot list them all. Right. Harsh, but
Hopefully maybe one of your own.
yeah, it sounds like someone having a bad day. That's just my, like I said, my experience is you go to court and you simply say, the difficulty is proving the unfairly prejudicial conduct. Once we've done that and we're over the hill, great. the order that follows, if that's the relief we sought, is court will order that shares be bought out by company or by other shareholders. We'll have a mechanism for valuation. We don't worry about the terms of how that's then followed through. But, it's just a different approach across the jurisdictions, isn't it? The case law then, there's a great body of case law dealing with this in the UK because, as I said, it tends to be the go-to remedy for the aggrieved shareholder. In contrast to the derivative claim here, the aggrieved shareholder is paying out their litigation fees, they're paying their costs with a view to achieving a remedy for themselves personally. And that remedy will normally be in order that their shares be bought out by either the company or other shareholders. So as to enable the aggrieved shareholder to take a clean break. They walk away, they've obtained, they've sold their shares, they walk away. But it's litigation that often involves then satellite litigation over the value of the shares. And this I've been going on for 2 years now, where we just cannot get to a common position on the value of the shares, and the court is being entirely unhelpful in us getting to a stage where we have some agreed value. You go to a single joint expert to value the shares. Neither party likes what the single joint expert has said for different reasons. You then go to court and ask for permissions. You go rely on independent expert evidence, and you do that. And then you're further apart than ever. And then you're going to kick it back to the court now to say, well, look, you've just got to make a judgment on it. But it does, that is the downside, is that the proceedings on liability then lead into proceedings on quantum, and those become costly. Nevertheless, you can look to various cases. There are, I want to say hundreds, there probably are cases where the court has deemed certain conduct to be unfairly prejudicial. The most common examples being exclusion from management. There's no particular reason for the cases that I've selected here, because there are just any number of cases that deal with these various issues, but these are probably the headline ones. So exclusion from management in circumstances where your shareholder had, I don't know, a common agreement or the expectation of being able to participate in management of the company has been excluded from doing so. That's very common ground. Mismanagement then by those who are in control, those who are participating in management, that may extend to breaches of the duty of care and skill and any other breach of fiduciary duty as the final bullet. And again, another common one where somebody's being excluded from management and cut out from the financial position of the company, excessive remuneration being taken by directors to the extent that they're effectively drawing their profit share by way of salary or other benefits at a directorial level, to the extent to the exclusion of paying dividends back out to the aggrieved shareholder. You have a couple of interesting cases where that's happened. The directors who are active in management have been paying themselves out remuneration at excessive levels, but have not been paying anything out, or declaring dividends rather. They haven't been paying anything out by way of dividend. And when the issues come before the court, they've tried to argue, as in Samuela, that the conduct isn't unfairly prejudicial because we, as shareholders wearing our shareholder caps, haven't had any dividends either. So we've suffered unfair prejudice because, look, we're shareholders, we haven't had dividends. You can imagine the court had very little time for those arguments and said, no. Took a quite ballsy lawyer, I think, to take that to court. The court didn't like that. So it's common then, certainly when I see a petition being pleaded, that you're putting together all these various bases on which you say the respondents have engaged in conduct which is unfair and prejudicial. And these petitions then will often run, but the court petition will be pretty straightforward, but the underlying statement of case then will run I don't know, the most recent one I did, I think, we had, I think it ran to 15 or 16 pages worth of bullet point allegations, because as much as the court just wants to see these broad categories, it's all entirely factual. It is entirely factual as to what has happened to mean somebody's been excluded from management, or more so, and in the case I'm thinking about, why the bulk came, was mismanagement. Going through exhaustively everything that the petitioning party thinks equates to mismanagement. And so you end up with this very long pleading. The other side responds to it, and so suddenly you've got pleadings of 30, 40 pages, and the costs are just escalating. And then you reach a point of no return because everyone's so invested in cost that they just, principle takes over. And then you end up with a settlement and mediation that nobody's happy with. But, yeah, that's just my experience of unfair prejudice petition. So, point being, you can look to a set of facts, and it isn't necessarily the case that you're shoehorning those facts into these broad categories, because it's the facts that underpin the unfairly prejudicial conduct. But just in very broad terms, that's the kind of things, those are the kind of things that you're looking for. I can't even read them. Sorry. I did this on one other slide, didn't I? Or I should have cut it off. But it's straightforward. So in terms of the relief that the court may grant under section 350, well, quite simply, as under the 2006 Act, it may make such order as it thinks fit. The court has its complete discretion to make such order as it thinks fit on the petition. Typically, the relief sought is in order to give the parties a clean break, that the shares of the petitioning creditor, the petitioning party rather, be bought out by the company or by other shareholders. It could be the reverse. It could be that the petitioning shareholder be ordered to buy out the other shares in the company, if that's the relief that they seek. That's possible. In either case, the court will determine the value of the shares. The court, though, can go beyond that. It has this ultimate discretion, and so Section 2 sets out other indicative forms of relief that the court may grant. It may regulate the conduct of the company's affairs in the future. So nobody gets bought out, everybody remains within the company, but perhaps a third party is brought in to negotiate or to break down deadlock at a board level. I've seen that in the past. They appoint an NED. To require the company to refrain from doing or continuing to do something. So to refrain from doing or continuing to do something, or the converse, to do something which has otherwise been omitted to be done. So it can direct the company, it can control the company, but the court really isn't going to have any particular interest in doing that. They authorize civil proceedings to be brought, again, on behalf of the company, so it can basically direct someone to bring a derivative claim, or to bring a claim, to say to the companies, the directors, you've got to bring a claim in respect of this matter. Again, I just can't see that being granted. It's the court's getting too involved then in internal issues. D, again, more commonly, to order that there be a purchase of shares. And E, probably again something that you may see a bit more often than the others, to prevent the company from making some alteration to its articles. That ties back in with what we discussed previously. The interesting, to me, interplay in the Guernsey law between alteration of the articles and the protections that are afforded there, and unfair prejudice. Because if you remember, there was that kind of built-in provision on the alteration of the articles that gave the court similar discretion to make an order on terms similar to what exists here under section 2 of 350. It's again the case. You're presented with a set of facts, you're working through the various provisions dealing with unfair prejudice. Your advice may be to proceed with a petition, but it's not just looking at liability, it's looking to the relief that the court may grant. And it isn't enough to simply say, well, look, these are the options based under section 350, subsection 2. you need to give a bit more of that, and based on the facts of what is the appropriate outcome here, what are the best options for the parties. Cobra, the Guernsey case, dealt with an application for injunctive relief in circumstances where the respondents were seeking to take control of the group. So steps were being taken by the respondent to take control of this group. And the applicants were concerned that as time goes on, whilst they pursue a claim under, while they pursue a petition under Section 350 for unfair prejudice, steps would be taken by respondent to basically consolidate the position, to improve his position to the extent of the applicants. And on that basis, the court granted injunctive relief pending the applicant pursuing a petition for unfair prejudice, such as to preserve the status quo in the company. The balance of convenience favors the preservation of the value of the group pending the various substantive matters that were an issue. But again, not something that I've seen in practice. But the court, of course, has its discretion to grant injunctive relief, here tied into the fact that the proper form, the ultimate form of relief which would be sought, would be a petition for unfair prejudice, but recognizing that that takes time to come to fruition. And so in the meantime, granting an injunction to prevent effectively further steps being taken by the respondents to further disadvantage the position of the applicant. That there is something then that you could perhaps briefly read up on in a bit more detail, because while we've got a quick 10 minutes left, we turn our attention so briefly to J&E Windings Up. Historically, the J&E Winding Up was treated in England, Wales as being another weapon in the armory of the aggrieved shareholder. If you're unhappy with the position in which you find yourself, go for the nuclear option. Go to the court and apply for the company to be placed into a winding up. However, it is the nuclear option. It ends with the end of life for the company. And on that basis, although the principles were pretty well developed in the common law jurisprudence, actually the English courts do not like J&E Windings Up, and there are barely any reported decisions on them because it is the nuclear option, and it brings everything to an end. Company is wound up, it's dissolved, and the court doesn't like it. The court's policy is, well, if we can continue the company as a going concern, then let's do that. And on that basis, you need to apply for relief by way of an unfair prejudice petition, because that can achieve a similar outcome in that you take the aggrieved party and you remove them from the company. Or, I suppose, conversely, you could remove the wrongdoers or whoever and leave it with the aggrieved party. Point being, the company continues as a going concern. Position in Jersey, as I said, very different. They use this as a much more flexible vehicle for achieving different objectives in circumstances where a company is probably failed financially, where it's no longer viable. And they use this to really seek to protect the reputation of the island, because it enables, the way they've developed it is to enable the company to continue to trade in a way that, as I said earlier, I see as a pre-pack administration. You just take the business of the company, put it into a new vehicle, the old company dies, and its debts die with it, and the business can continue. but with various safeguards to make sure it's not just a phoenix arising from the ashes. The Guernsey jurisprudence, well, it's relatively limited, though we come back to the case we mentioned earlier where they did grant a JNE winding up. But just as a starting point, section 460, company may be wound up by the court if the court is of opinion that it is just and equitable, the company be wound up. It doesn't take us further than that in understanding what the JNE winding up is or the circumstances in which it ought be applied. In Midland, which is a couple of slides on, I don't know if I noted it in that. No, I didn't. Oh, yes, I did. So in Midland here, in the Guernsey judgment we were just discussing in the context of unfair prejudice, the court draws here the clear analogy, the clear link with the jurisprudence in England and Wales. The relevant English authorities are to be regarded in this jurisdiction as being highly persuasive. And ultimately on the facts, the court went ahead, instead of ordering, as we said earlier, the grant of relief on the unfair prejudice petition, it granted the JNE winding up. So clear authority to look back to the English provisions, and those start with Ibrahimi. The legislative framework is no different to what you have here in Guernsey. It's just a single sentence that says the court can wind a company up if it's just natural to do so. And that's it. So you then look to Ibrahimi as the starting point, where the court developed, really for the first time, the key elements that it's looking for in order to order a JNE winding up. Here you've got Ibrahimi, who was in an existing partnership with his business partner. It was an Oriental rug business. And they'd been in partnership for 10 years or so. So there's a long-standing relationship between the partners. They participated equally in the business, in its management, etc. They shared equally, I think, for the most part, in profits, etc. And as time goes on, it's decided that Ibrahimi's business partner will introduce his son into the business. And ultimately, they incorporate Westbourne Galleries to take advantage of the benefit of limited liability. There's no suggestion that they were in any way ill-advised or seeking to take any kind of advantage by putting the partnership into a limited co. No, they were just seeking to take the normal benefits of using a limited company. So they do that. They incorporate Westbourne Galleries, and the son of the business partner enters as director and shareholder along with Ibrahimi and the business partner. However, the relationship begins to break down, and ultimately Ibrahimi is excluded from management by the business partner and son. To the extent that the catalyst for the court proceedings is that Ibrahimi is voted off the board. So he's removed at board level by son and business partner. And Ibrahimi petitions for relief, and it's ultimately his petition for JNE winding up that succeeds on the basis that, notwithstanding the fact that the parties had incorporated a limited co, the basis of their relationship was personal. They knew one another. It's not as though they were anonymous shareholders in a public company, a listed company. There was just originally the two of them, and then the three of them. Their relationship was personal. They knew one another, and they had mutual trust and confidence in each other and the carrying on of that business. The fact that the business had started out in partnership meant that the court had no difficulty in establishing that that means there must have been a common understanding that the parties would each be entitled to participate in management to the extent that they wished to do so. That, the court said, the personal relationship, the mutual trust and confidence, the equality in participation and management. Those are all things, the court said, which would generally be proven in any situation where an existing partnership is transferred into a limited company, because it's not uncommon. What was peculiar on the facts in Ibrahimi is that there was a restriction in the articles on the ability of Ibrahimi to sell his shares and take a clean exit from the company, which again is hugely uncommon. The more practical point was who would want to buy a private shareholding in a small Oriental rug business. There's that practical issue, you see. You can't just take your shares, sell them as an enlisted co, and walk away. So that barrier to exiting the company also factored into the court's decision to order JNE winding up. The court was satisfied that this was, for all intent and purpose, a partnership that just existed within the framework, within the vehicle of the limited company. And equality is what is to be expected in partnership. There was nothing to the evidence the contrary. And on that basis, in order to give the parties a clean break, it ordered a JNE winding up. So the company is placed into liquidation, assets are realised, proceeds of sale are distributed, and in theory, Ibrahimi walks away with something more than he could have ever realised if he had been forced to sell his shares. Because in a small private limited company, there's no market for those shares. There are then various examples of cases in which the court has ordered JNE winding up. Ibrahimi is the leading case, notwithstanding that some of these are earlier. Ibrahimi is the leading case because the court recognised these kind of factors to which it would have regard. But nevertheless, you can see other examples of the grounds on which the court was satisfied a JNE winding up should be ordered. Where the company's substratum has failed, i.e. the commercial object for which the company was formed is no longer capable of being achieved, which is obviously hugely fact-specific. The whole purpose of the company is broken down. So in terms of what do you do next, the court was satisfied. You place it into a winding up, extract the asset value, distribute it, and dissolve the company. Fraud was used as a basis in Thomas Edward, but that's 1887, and now probably, if in a situation involving fraud, I don't think you'd look to petition for JNE winding up, because we have statutory powers, as we know, that exist within insolvency to seek remedies for those who are aggrieved by some kind of ongoing fraudulent conduct. But nevertheless, deadlock, so again, where there's complete deadlock across the board and there is no hope of reconciliation. Again, that's 1916, I think now, if that was to come before the court, it would say, come back to us with a petition for unfair prejudice. Deadlock alone, I don't think would be enough to justify the apocalypse for the company. I don't think it would be sufficient. The court would say, come back with a petition, and either we buy one of you out to resolve the deadlock, or we appoint someone in to break the deadlock. Justifiable loss of confidence in management. Yeah, again, you can see it in Ibrahimi's case to an extent. He's excluded from participation. He's lost trust and confidence in his former partner. And the court is satisfied to grant a JNE winding up. But all of these, again, subject to the point I come back to, which is the court doesn't like it because it brings an end to a going concern. And the fact is, if that could otherwise continue through some other form of relief, then the unfair prejudice petition is probably to be preferred. Now, whether or not the Guernsey courts would take the same kind of rationale to that as the Court of England and Wales has, I think we can say the Guernsey court, based on the comments in Midland, will probably be closer to the English position. But as I said, don't look too much to Jersey, because it is totally it's dealt with totally differently over there. But nevertheless, kind of my final point, you've got a general set of facts dealing with various issues that leads you down the path of thinking, could this be derivative claim? Could this be petition for unfair prejudice? Don't lose sight of the fact that the JNE winding up is still an available remedy. It will, there's no reason why it wouldn't be granted if the various factors in Ibrahimi are satisfied, and looking to the wider body of jurisprudence. In fact, you look to Midland, you look to the fact that the Guernsey court has recently ordered a JNE winding up, and think maybe they will take a more pragmatic approach to its use. Yeah.
No, but I will make inquiries.
I think there was an announcement, I think it was on it, so he might.
If I've done a briefing, I'll
Yeah,
circulate it.
perfect, thank you.
Yeah. So yeah, don't lose sight of that. You're putting together advice. It remains a remedy. It's still something that exists in your arsenal as litigators, but from my point of view, it's something we tend not to pursue.
And I think one pushing on, yeah, and then we can get to it, so I'm not sure whether this. I looked on
Has the judgment not been published yet?
possibly not, it was just a very brief, we acted
It's
not
not,
just an
yeah.
approval, so.
Maybe that's what
There may
maybe
even be a written judgment. on
Yeah.
it.
I would have thought. Maybe I'll come out in the reports. Fine. So look, I'll come back to bring a lot of this together, I think, in the next study weekend, where we can look at some more practical examples and how we'll work through those for the purposes of the exam. But with the benefit of having Fran here. Have you got anything else you want to add to what we've discussed, or have you got any queries?
From my point of view, no. I would agree with what you say. I'm just an equitable as a practitioner. Where we have closely held companies, we would look to a minority prejudice rather than JNE. They're interesting with a limited partnership because you have so few remedies. The only thing which your limited partner, who naturally can't get involved in the business, has no say. It probably would go to JNE because that's one of the few remedies there are. But certainly I will speak to Gordon about his case and just see if there's anything to add to the discussion that we've had. But certainly from my experience, I very rarely see these.
Yeah. And any other questions then? While Fran's here.
That's fine. You know where I am, and do just drop me a line if there's anything you want to discuss, about the corporate, or very happy to answer.
Thank you so much.
It's been an absolute pleasure meeting you all, and I've learnt quite a lot this afternoon.
We'll have our uses, I suppose. Fine, well, thank you all for listening so attentively again for another session. And I'll see you in 2 weekends, in a fortnight's time. And we'll, as we said, go for Friday, 5:30 till 7, and then Saturday night till 3. And we'll look a bit more practically at the assessment and what you need to be looking out for.
You have the costs. You also need to have the application that SDLs or to be run by the.
All right.
Was that Fountain Street, did you say?
Yeah.
Yeah, okay. Yeah, that's fine. I have come across that.